All right, welcome in, students. This is going to be your review for the final exam for BUL 3130. It's going to be fairly quick, not a lot to go over. A couple of things just to kind of give you an idea of the exam and what it's going to be. You will have 49 questions. That will it was originally 50, but there was at least one duplicate that I found, so I removed it. So it's 49 questions, with 45 of those being multiple choice and 4 of those being the essay questions that you would normally see when we do the quizzes. So there's 4 of those instead of the 5, but they are worth 4 points apiece instead of 3. So it kind of equals out to the same amount of points that they're worth. Actually, one extra point in there. So as usual, it would be a good idea to start with those and work your way back. You do have 1 hour and 45 minutes to complete this, so it gives you a little bit of time in there, but you do still have to stay within a time frame. So make sure that you're getting those done. The bulk of those points, 16 points you could lose right off the top. So that's not the most ideal way to lose your points in. Okay, so getting into this, so how I will do this is I'm looking at the exam and I'm going to go over a few pieces of it just to kind of give you an idea of basically stuff that may not be as easy to kind of just look at it and comprehend, and may cause you to spend a lot of time looking up through the book. I'm going to try to save you some time there. So hopefully as you're watching this, you'll be taking notes, and you can always reach out to me before the exam is open to kind of give you a little bit of help also if there's something that you do not understand. So I am going to start off, and let me open that up. I'm going to start off with a case that it mentions from the book. Just have to sign into the book here real quick. The case is Lefkowitz versus Great Minneapolis Surplus Store Incorporated. It's a case that would have been alluded to in the book, dealing with part of the advertisements, type thing with contracts and what performance would be and those type of things. You do have quite a few contract questions in this, so it's going to be important for you to kind of, make sure that you're brushing back up on that. It was fairly recent, but it was back at the beginning of this half of the term. And while I'm on that subject, all of the information covered in the final will be information that we have gone over since the midterm. So nothing before the midterm will be on here. Everything is dealing with the chapters after the midterm. Just waiting on it to load real quick. While I do that, I do want to say to all of you, thank you for a great semester. You have made it an interesting semester at times, and you have been just tremendous in your questions. The questions that you've sent in on Canvas and some through the Outlook email, those have been very good questions, and I do appreciate those. I've started grading the how did we do discussions. As you turn those in, I kind of look at those, and thank you for your input on those so far. Those have done that. Make sure that you're getting that done. That is due this coming Sunday night. It's worth 10 points, so make sure you're getting it that free 10 points just by completing that little 4-question survey that I put out there, and be truthful with it. Let me know what you like, what you didn't like. Let me know what you think could be improved upon, and how you plan to use this. Is it going to be in your career? Is it going to be something that's going to help you life wise? Are you going to plan on starting a business? Let me know how this applies, some of the application that you plan on using it for. All right. So the case, the Lefkowitz case, is in chapter 10. That gives you an idea of where that is located. The case is dealing with an appeal for an order of judgment that is an award to the plaintiff. Once again, it is Lefkowitz versus Great Minneapolis Surplus Store, and it's about an invitation of seeking offers. All right, so let's go to the final exam. The court held that the newspaper advertisement was an offer because it contained a promise of performance in definite terms in return for the act. And that case, of course, is going to be that. So how the court held. Whether an individual instance in newspaper advertisement is an offer rather than an invitation to make an offer depends on legal intention of the parties and surrounding circumstances. The court said that they are the view of the facts before them offered by the defendant was clear, definite, and explicit, and left nothing up for negotiation. In other words, it was a clear offer that was made, and the plaintiff, having successfully managed to be the first one to appear at the seller's place of business to be served, as requested by the advertisement, and having offered the stated purchase price of the article, was entitled to performance on the part of the defendant. So they found for the plaintiff, stating that Lefkowitz should have been awarded those items because they were first on the scene. They met everything that was required in the offer, and they should have received what they were there for, fur coats in this case. And that is the only specific case that you'll see on here. So if you just kind of keep that in mind, sometimes those cases can be a little difficult to find and to understand. So wanted to make sure that I gave you a little bit of assistance with those. So we're going to start with looking over these essay questions. You have one that deals with someone providing a service under contract with a party. So you have party A and party B. They are under contract for a service to be done. Party A mistakenly stops at a different residence than what party B lived at through a mistake of theirs. And in so doing, they complete the service that was in question. They complete that service, and they do so in the manner that had been agreed upon with the original contract. And they do that, and the party for who the service was mistakenly done does not say anything, does not in any way go out and say, hey, we didn't ask for this, we didn't call for this or anything like that. They made no attempt to stop the performance of this contract. So what you have to decide, and what it's going to ask you, is the party who mistakenly received the service, are they obligated to pay party A for doing the service on their property, even though they were not under contract originally, or will they be required to do that? So you have to dig into contracts a little bit and look at what the premise would be for a mistake on behalf of the parties. Now, there's quite a bit that talks about mistakes and how mistakes work. Other contracts, so you have to look at that. And it's going to ask you to explain your answer. So I want to stop for just a second and go into that last little part. 3 words. Those 3 words are the difference between 1 point and full credit for the question or your answer. If you just simply say yes or no and give me one little line that says something about the service performed, so they're under, or the service they didn't ask for it, so they're not under obligation. If that's all you say, you're not explaining the answer. So make sure you're explaining the answer. The last, not the most recent quiz you did, but the last one I graded, there were quite a few of those real short answers, trying to just throw something on there, and those did not receive full credit a lot of times. Now, there are some cases, there is at least one question on here that simply says, give an example of each of the following. There's 2 things, and you give an example of those. You don't have to explain it, you're just giving an example. So that will be, easy if it's 1 or 2 lines. But if it says to explain, that means you need to give an explanation. And keep in mind, this is a test, a exam that's based in law. And so legal terminology is important in your explanation. The book has the legal terminology for you to use as you're doing this. That shows you understand what it is. So if you're using that legal terminology, you should be able to, know what is there and explain the case based upon that legal terminology. So make sure you're using all of those pieces that we've learned over, the last few weeks as far as the second half of the term, but we've learned a lot of legal terminology throughout the full term. So make sure that you're, applying everything as far as what you've learned to that question, but that specifically it's going to be about contracts. So make sure that you're, doing that in that way. So there are a couple of questions about employment law, and one of those is about the age to which the Age Discrimination Employment Act applies. What is that age? Where does that apply to? There are questions about copyright, patent, trademarks, service marks, a few of those. So make sure that you're kind of going over those. If someone wishes to protect an original work of theirs, which of those would they use, a copyright, patent, or service mark registration? In that case, it's because it's original work, you would put a copyright on it to make sure that it is fully protected. What is Social Security benefits? What are they, and how are they funded? They're funded by both the employer and the employee, both pay those taxes. Make sure you're familiar with what the RMBC is and what it permits and how it works as far as corporations go. Let's see. What's the principal source of corporate financing? There's a question on that. There are quite a few questions on corporations and how they work, and partnerships. So your legal entities that we talked about, your business entities, look into those. Questions on equity and debt, as far as how they fund a corporation, how a corporation can receive funding through equity and debt through those types of securities. So make sure you understand those. Understand what partnerships are, how someone can be a part of a partnership but have limited liability, the differences between a general partner and a limited partner, and also the similarities between them. There are a couple, but make sure you know the differences also, that you could pay attention to those. Your main differences between a general and a limited. A limited partner does not have any say in the day-to-day operations. They do not handle the management of that partnership. They do receive limited liability. They're not liable for the debts of the partnership. Also, they are protected as far as lawsuits against the partnership, those type of things. They have that type of protection. They're also, let's see, that kind of covers that. Understand what common and preferred stock, the differences in those. You may not see the words common preferred all the time, with them being eliminated through the Revised Act. Remember, common stock does not have any special preferences or rights. And then you have, it bears the greatest risk of loss because you're not guaranteed a payout. And if liquidation was to occur, no one's guaranteed that other than the debtors. But when you have a better chance if you have stock that comes with those rights as opposed to the rights that come with common stock. I know that uh, sales of copyrights, patents, and the law that covers copyrights, patents, trademarks, and those type of things we talked about with intellectual property, they are covered by federal law and federal statutes. They are not in other self-handled by the states. They are handled by federal law. It is departments that handle that type of stuff. If you get a copyright, it's a federally protected copyright. If you get a trademark or a patent, they are handled through the U.S. Patent Office or the Copyright Office through those places. So make sure that you understand that those are federal in their structure. Know what the definition of a merchant is under the UCC. Merchant sells a particular item. They deal in a particular item. They have a particular craft that they do and make money off that craft. That would be a merchant. Someone who just sells all kind of stuff, maybe not so much. But someone who deals specifically in IBM computers or homemade furniture, they would fit into that. Know what actual fraud is. If any one of these statements was false, we need to know kind of which one of these would be actionable fraud. In other words, you could bring a suit based upon it. If a car owner is trying to sell a car and say this car is the best buy you will find, you may find another buy, but that's not going to affect you one way or the other because that's something prior to you buying it. It may not be what you base it on. An art dealer saying this painting will increase in value. That's a possibility. A stockbroker statement this stock should double in price within 6 months. Notice the should there. Or a realtor statement that the contractor used 25-year warranted shingles on the roof. That one is specifically talks about a warranty and says that it was used, throws a contractor in there, which puts the professional side behind it. So it's a good, something that would be expected to be reliable, and you would make a decision on that. Someone saying this car is the best buy you will find, well, that may not be that's a matter of opinion. Stock should double in price. It's not saying that it will, saying it should. And this painting will increase in value. Most paintings do if they're being sold by an art dealer. They're expected to increase. But the contractor used 25-year warranted shingles. That is giving us a very specific way of saying that, this will be good for 25 years. And that would be one that could be actual fraud if that is a false statement. Understand what infringement is as far as a trademark goes, or a mark of some sort of service mark, any of those, collective mark or collaborative mark, any of those, know what those are, a certification mark. Putting the UL symbol, the underwriter laboratory symbol, on something that's not certified by them, uh, using someone else's identical or substantially similar mark. When we were doing the lecture, remember I talked about Walmart and their asterisk on their background, the yellow asterisk or yellow star, or whatever you want to call it, on their blue field. Someone using something identical or some substantially similar to it could be infringement, especially if it could cause confusion or cause a mistake, or if it's an attempt to deceive. That could be something that would be considered infringement. Using the target target symbol, the bullseye symbol that they use, would be something similar to that also. A foreign limited liability company. Keep in mind that foreign, in the sense of companies, corporations, those type of things, it means a different state from the one it's working in. Walmart is a foreign corporation or a foreign company to the state of Florida because they do not have a home office here. So understand that that's what it means when it says foreign. So a foreign limited liability company would be governed by the laws of the state it comes from, where it was organized, where those articles were set up for the company, whatever paperwork they filed to be a limited liability company, that LLC paperwork. They're considered foreign in any state other than the one in which it was formed. They must register with the Secretary of State before transacting business in a state other than the one they are formed in. Those type of things are very important. So you want to make sure that you understand those and what it means to be a foreign company, a foreign limited liability company, a foreign corporation, whatever that entity may be. What does it mean when they're foreign, and what type of laws are they governed by, and what do they have to do to operate in a state that is not their domestic state? So understanding those will help you with about four of the questions that I've seen so far. Uh, Thinking of contracts and the real simple part of contracts that we talked about with contracts, those three parts: your offer, your acceptance, and your consideration. An offer can be for a limited time. If I put out an offer for an item for sale at a set price and say that this offer is only good through close of business on Friday, any acceptance received after that point saying they will buy that product for that price, if it's after the expiration of that offer, is that party then giving me an offer? They're creating their own offer. They're offering to buy that product from me because the original offer that I set up no longer exists because it expired. Through expiration, that no longer is in place. So that doesn't exist anymore. And so we now have a new offer that is being put out by them. And I, as the one with the items they're seeking to buy, would have to accept their offer for a contract to be created on those with those pieces. So it's important to understand that, once an offer goes away, you cannot accept it anymore. So if it's expired, you can't accept it. And if you send an acceptance based upon those terms, you're just making a new offer with those terms in it. There are a few questions about bailments here, dealing with property and what happens if property is left or not around. Someone leaves a hat in a restaurant. How does it become a bailment? If the manager finds the hat, then it would become a bailment. So that's how it would be. Someone else is in possession of it. So someone makes a promise to pay for an item on the condition that they receive an inheritance. Uh, they're, when you're doing it based upon a condition, is it legally sufficient as far as a promise goes? So a promise itself, not so much. the full setup contract, but a promise that a person would rely upon. A legally sufficient promise exists there unless Janet knew at the time she made the promise that she could not inherit the 1 million. If she fully expects to inherit the 1 million, no matter if there's, it's imminent or at a future time, but she knows that she will inherit it, she's basing that promise off of a known, uh, a known truth. And so by basing it on that known truth, she is then telling someone, hey, I'll pay for that and buy this from you at the point I receive this money. I would be the same as, for a fact you're getting a paycheck on Friday. You tell someone, hey, I'll be back on Friday to get that item when I have the money. Think of that in terms of not as far as the offer part of it, but in terms of in this case, an offer to buy, not an offer to sell, but an offer to buy. Think of it as an offer to buy. So once that is, that money has been placed in their possession, they are, legally obligated to go make that purchase if that item still exists. The NLRA, or the National Labor Relations Act, is also known as the Wagner Act. Brush up on those acts that we dealt with at the beginning of employment law and know what the other name is. So some of those have a name that makes, the National Labor Relations Act. But when those acts are normally started, they may carry a name for the senators or representatives who created the act. It'll have their name too. That'll be partially how it's known. So, kind of understand those, keep those in mind. Let's see. All right. Couple of more here. Kind of about made it to the top of this. So I did not technically go in order with this. So your notes may not be in the order that you see the questions. You just need to make sure that you understand your notes. There is one about a payout for an insurance claim. An insured individual holds a $32,000 fire insurance policy on the building, which is valued at $40,000, on which there is an 80% co-insurance clause. If the building is totally destroyed by fire, the policyholder will receive $32,000. That 80% co-insurance is based upon the value as it is valued of that building, which is $40,000. 80% of that is going to be paid, and so the 80% of that would be $32,000. You take off that other amount, the other 20% there, it's that $8,000 that's missing out of the value, and so they would receive $32,000 for that payment. A derivative suit. Let's talk about a derivative suit real quick, and this will be the last one, and I'll wind up, cover a couple of things real quick. A derivative suit is brought by a shareholder on behalf of a corporation to get an action based upon something that has been done by the management of that corporation. So a derivative suit is established to help the corporation, and the owners bring it. So the shareholders, the ownership brings that suit. Things to keep in mind with a derivative suit. In a derivative suit, the shareholder is not looking to receive compensation. They are trying to have the corporation compensated. In other words, they're protecting their ownership. They're protecting the ownership they have by having the corporation made whole or receive compensation based upon something that is done. In the case of maybe a president or CEO engaging in acts that are ultra vires acts, the acts that go outside of where it should, they may bring that because it could be something that is harmful to the corporation itself. And so, if they bring that, the goal and how the courts would handle it, the courts would award compensation to the corporation, not to that individual stockholder. They would require that changes were made and that whatever happened would be fixed in that instance. So let me make sure real quick and go through this and check and see if there's anything that I think might need a little bit more coverage. All right, so we have a business, and someone in particular in the business is agreeing to do a service for someone else. They agree on a set price, of course. They have everything in place that a contract needs. They agree on the set price. In the course of completing the performance, the service provider realizes there is an impediment which will prevent them from completing the service. They talk to the uh, party who is receiving the service and tell them that, well, this impediment prevents us. There is a way that I can do this, but it will cost more money. I will need to, add to the price of what we're doing. The party needs the service done. They agree to the extra amount. Once the service is completed, everything is done. The party who received the service changes their mind, says they're not going to pay for it. By law, they are obligated because they changed the contract. They agreed. So think about parole evidence here and how that worked. They agreed to a substitute contract that discharges the original contract, and it now is for a amount more than what originally was. And so that party is obligated to pay that amount because the terms of the substitute contract have been met. So keep in mind that when the parties agree, so you have a contract in place, but when things arise that cause the original contract to be changed and the parties agree to a new contract, it does away with that original contract, and the parties are then bound by the new or substitute contract. They're going to be bound by that new or substitute contract to whatever the uh, terms of that contract are. So make sure that they or that you understand that they're going to have to pay that extra. They're going to have to do whatever that new contract is asking. Performance, that consideration is there. The performance happened. They now have to come up with their part of the consideration. And I think that is going to pretty much take care of that. I think most of the other stuff is some form of what I've talked about already, or something that you may have actually seen in one of the quizzes. There's at least one question on here I know that was on a quiz. So that one should not be too awful difficult for you. There are probably a couple more that you've seen before that I just haven't uh, noticed those. All right. So there is one question that talks about the transference of interest in a limited partnership. So understand how that transfer can happen. Approval of the other partners is how that would work. Okay. Yeah, I think that's going to cover it for us. Now, there's at least one or two questions that match up to. Yeah, they match up to questions you've seen before, or at least they're similar to it. All right. So if you have any questions after you watch this, please reach out to me. Uh, I'll answer any questions about the exam up till the time it opens and after it closes. If you take it and you have a question, a specific question about one of the questions on the exam that you think the answer, and this will apply to the multiple choice only, but if you think that answer doesn't align with what the book says or how it was presented, reach out to me so I can give you some clarification on it. I'll go through these to make sure, because there have been issues before where the um, where these question banks are built through Cengage, and sometimes there may be a little bit of ambiguity there that needs to be cleared up. So if you see that and you pick the answer that you think is correct, and you see that answer is wrong, it's not going to give you the correct answer, but it will tell you if it's wrong. Reach out to me so I can give you some clarification on that. All right. So the last thing I want to say, and I think I said it at the beginning, but I want to reiterate it to you. Thank you for a great semester. Y'all have been super, and I hope that everything you do from this point on is successful for you. I hope you lead successful careers and have successful lives, whatever that may mean to you. Don't judge your success by what other people say. Judge your success by what your goals are and what works for you. So, as always, stay safe, study hard, and good luck on the exam.